Citizens of Ukraine can henceforth apply independently to the Constitutional Court to protect their rights. It is about the possibility of lodging a constitutional complaint. This innovation is undoubtedly a major advantage of judicial reform in Ukraine, according to experts. Citizens are actually granted access to constitutional justice in the form of submitting a constitutional complaint. If a citizen has exhausted all remedies in courts of general jurisdiction and considers the law applied by the court to be unconstitutional, he has the right to lodge a complaint with the Constitutional Court. The experience of foreign countries which use constitutional complaints shows that citizens effectively apply to the constitutional oversight body to protect their rights, since these bodies' decisions have a fairly serious impact on the legal system. For example, in Germany, the number of complaints reaches 10,000 per year. Therefore, to administer them efficiently, it is necessary to divide the court into several divisions, in particular into separate boards. According to the judicial reform, 6 boards will be established in Ukraine. Each of them will include 3 judges from the Constitutional Court. The boards will decide procedural issues. Constitutional complaints from citizens will be considered by the Senate. Each of the 2 senates will include 9 judges. All other issues will be decided by the Grand Chamber, where 13 of its servants will pass judgment. 5 posts have been left vacant. However, according to the law, before November 3, 2017, a competitive selection to the above posts of the Supreme Court must be announced. The model of the judicial system was taken from the experience of the Italian Republic, when formerly 3 bodies of power form a single constitutional oversight body: executive authority, the parliament, and the head of the state, according to Judge Igor Slidenko. However, in Ukraine, the reform was refined, bearing in mind the negatives that occurred in the previous years, when the decision on the appointment of those or other judges was adopted behind closed doors in a useful way. Currently, special competitive commissions have been approved. So special competitive commissions will recommend candidates for appointment to the Constitutional Court. And bodies of power, including the President of Ukraine, the Parliament, and the Congress of Judges of Ukraine, will choose the best candidates. There is another fundamentally new change, as experts emphasize. If before 2017, in fact, requirements for the position of judge were formal, such as certain age, education, practical experience, now there are new factors in the legal system of Ukraine. For example, a reputation, both professional and ethical. That is, the extent to which an applicant, in terms of ethical standards, meets his position. Therefore, the main thing is the involvement of citizens, the objective coverage of the situation on media, and the active position of those citizens who really want to change their country. If we don't look out for ourselves, who will? The new law on the Constitutional Court of Ukraine came into force on August 3, 2017. For the first time in history of the institution, the reform has put a limit to the power of the body and has changed its structure, activities, and mechanisms of implementation. In accordance with this law and the amendments to the Constitution, the Constitutional Court lost some of its powers that it had executed for the last 20 years and acquired new ones. Another innovation is that the law has codified all relevant procedural rules of the Constitutional Court. As before 2017, they were contained in various versions. Reform of the judicial body is a part of the general judicial reform and judicial amendments to the Constitution. Because these things affect not only the judicial system and judges, they also affect the prosecutor's office, the bar, the issue of access to the legal profession and legal education, and the issue of the Constitutional Court, respectively. According to the reform, now judges take an oath during a special plenary session of the CC and not in the parliament, as it was before. Competitive selection will not cover those judges appointed before the entry into force of the new law. Now the Constitutional Court is involved in specification of the legal norms that will be completed in the near future. The law provides 3 months for this. That is, in late October, the implementation of the legislative framework is to be completed by the adoption of the regulations of the Constitutional Court. Regulation is a procedural act, which the CC will apply during its activity.